Hi, cześć from Warsaw in Poland. As I speak, it is the end of January 2021. For nearly 1 year now, we have been living with a virus pandemic in Europe in the form of COVID-19, a severe respiratory illness causing serious business challenges and changes in the law in an attempt to address these challenges. This is News from Poland, Business and Law, a synthesis for foreign directors of Polish companies, foreign investors in Poland and their foreign lawyers. In line with this program's formula, I will tell you about what is currently happening in the Polish economy, as well as about accompanying changes in the law. So, what is the general picture of the Polish economy? There is currently a lockdown in Poland. Schools, most stores in shopping centers, movie theaters, gyms and hotels are closed. Restaurants and bars can sell food, but only as takeout or with home delivery. There are no mass public events. However, there is no curfew in Poland, as in France. The wearing of masks is compulsory in mass transport, public parts of buildings, in office corridors and on streets. Interestingly, people truly abide by this order. Industrial production continues without greater obstacles. Poland is doing well in this regard because the industrial production sector is relatively large in our economy. Export is doing very well because key export markets remain open and supply chain disruptions have passed. Altogether, 80% of Polish exports flow to other European countries, primarily to Germany. In result, Poland has a record export surplus. Therefore, there have not been and there are no mass layoffs in industry. Poland has one of the lowest unemployment rates in the EU, namely 3.3%. This is outstanding. In comparison, it is 4.5% in Germany, 8.8% in France and 16.4% in Spain. Unfortunately, fluctuations in COVID-19 infections cause unpredictability in administrative decisions, particularly over the closure of specific sectors of the economy or the entire country. This has led to waiting and resulting suspension or reduction of investment by Polish enterprises. Companies in sectors facing consequences of the pandemic have received quite significant financial assistance from the government. However, the number of bankruptcies may increase rapidly after this assistance ceases. I will now discuss following significant changes in the Polish law. The coronavirus was first uncovered in Poland on 4th March 2020. On 20th March, a state of epidemic was announced and the first lockdown took place. The government prohibited everyone from leaving their home, except in cases of travel to work and purchase of basic products. It then became obvious that, firstly, closure of the economy would mean that some firms, prior to receiving aid from government, would become insolvent, which by law would require them to file for a declaration of bankruptcy or restructuring. And secondly, a sudden deluge of such applications in court would lead to enormous delays in their review. As a result, prior to debtors receiving protection against enforcement, their assets, funds in bank accounts and equipment would be seized by bailiffs acting on behalf of creditors, and staff would be let go. In order to prevent this, a so-called moratorium on the filing of bankruptcy declarations was introduced in Polish law on 13th April 2020. What did it entail? In the case of a company becoming insolvent, the management board or any one of its members should file a bankruptcy application. The deadline is 30 days from the date when a company becomes insolvent. When is a company insolvent? When it loses the ability to meet its due monetary liabilities. It is presumed that such a state arises if delay in meeting monetary liabilities exceeds 3 months. If a company does not file a timely application to declare bankruptcy or commence restructuring, management board members are personally liable for satisfaction of company debts. A dilemma would arise: file for bankruptcy to protect against personal liability for company debts, or risk waiting with such application. The moratorium resolved this dilemma. It stipulated that if insolvency arose during the state of epidemic and due to COVID-19, the 30-day deadline for a company to submit a bankruptcy application does not commence. and that which has commenced is suspended. If insolvency arose during a state of epidemic, it is presumed that it appeared due to COVID-19. That is all for now. I wish you all the best. Take care. See you soon.